Let's continue our discussion on remedies, and we'll now move to the next interest that courts sometimes attempt to protect in a breach of contract situation, and that's an equitable interest. Remember, in the law, whenever you see the word equitable or equity, usually that means fairness. So this is like a fairness interest. The court's trying to be fair. Sometimes we'll find in here, as we talk about equitable interest, that money damages, which are the normal award from a court, right? All of our damages so far that we've talked about, compensatory damages, consequential damages, even reliance damages, those kinds of, are the payment of money from one side to another. But sometimes money damages just are not adequate for some reason to compensate the non-breaching party. So in those cases, courts use their equity or fairness powers to come up with some alternative remedies that they can order. And the first one we're going to look at is the equitable remedy of specific performance. Specific performance is the remedy where the court orders the parties to perform under the contract by court order. Notice it's only available where money damages would be inadequate. And I've got some of those contexts listed there. We really only see this in a couple of contexts. One, where you have unique goods that are the subject matter of a contract, and or the sale of land. Land is always treated a little bit differently in contracts, and this is no exception here under specific performance, because this remedy is typically available, at least to the buyer, in a land sale contract. And the idea is that all land is unique. Let me give you an example of why we do this or how this works. Let's say that you have a painting that is an original Picasso painting, and I want to buy it from you, so I sign a contract to buy it for $2 million, and we're going to close the sale on Saturday. You're going to bring the painting, and I'm going to bring the money. We get to Saturday, and I bring the money, and I tender my performance. I'm ready to give it to you, and you don't give me the painting. And you say you've changed your mind, that you don't want to give it to me now. You have seller's remorse, or maybe the market value you think is going to go up, and $2 million is now all of a sudden not enough. Whatever reason, you breach the contract. You don't perform. And so I sue you. Well, when I get into court, what am I going to ask for in terms of a remedy? What am I really going to get? Well, I might be able to sue you for some sort of money damages in terms of reliance interest. Maybe if there's a change in the market value of the painting, I might be able to get a difference between the market value and the contract price. But really, that's not going to ever give me what I contracted to get, and that is the painting. And no matter what amount of money that the court awarded me as a remedy, I wouldn't be able to take that money and go out and buy another one just like it, because it's unique. So therefore, I'm never really going to be made whole. I'm never really going to get the benefit of my bargain. And so courts will say in their fairness or equity powers, they might give me the remedy of specific performance, which is another way of saying the court would enter an order forcing you to give me the painting. Now, it would also force me to pay you for the painting. Basically, specific performance is when the court orders the parties to perform. And again, this is not available for every contract, and we really only see it where we have unique goods like this. One other note I might make here and mention at the bottom of the slide, it says this remedy is not available for personal services in a personal services contract. If you think about it, it makes some sense. If I contract to paint your house for you, and you're going to pay me $500, that's our contract, and I don't show up. You really want me to paint your house, but I won't perform. I just refuse. If you sue me and get it to court, a court won't give you the remedy of specific performance, because what I'm giving you are personal services. And what that would result in, if the court were to give you specific performance, is they would order me to come work for you. Basically, there would be a court order for me to work for someone else. And there are a lot of reasons why this is maybe not a good idea. Chief among those is, what kind of performance am I going to give you if the only reason I'm doing it is because I'm ordered by a court to do it? You can imagine the type of quality, in painting that I would give you under those circumstances. Also, public policy reasons, we don't like the way it looks. It's basically a court by law forcing one person to work for another. And it looks a lot like involuntary servitude or slavery. And so we just have come up with a blanket rule that this remedy-specific performance is not available for personal services contract. Okay, one tool that courts use and will grant from time to time using their equitable powers is an injunction. You might have heard this term. Basically, an injunction is a court order requiring one party to do something or stop doing something that's causing harm. It's usually phrased in the negative. You hear about cease and desist orders from time to time that courts will grant. Well, it's basically an injunction. It's a court order stopping someone from causing harm. And there are really two kinds that we talk about when we talk about injunctions. There are preliminary injunctions, and then there are permanent injunctions. And just like their names imply, a preliminary injunction is a court order that a court will grant, stopping the parties from performing under a contract or doing whatever it is they're doing to cause harm until a court can have a full hearing on the merits, on the issues of the dispute. Because sometimes one party is operating and causing harm to another, and we don't have time to stop and have a trial because the court system is slow, and the preparing for a trial with all the discovery that's available that takes a long time. And if we waited until a trial and allowed one party to continue causing harm for that whole time, then the harm might be what we call irreparable. Right? We can't go back in time and undo it. So courts sometimes will give a preliminary injunction, which is a court order stopping someone from doing something, performing a contract or otherwise, until the court can hear the merits. And we'll take a look here at the basic elements that a court requires to be proven in order to issue a preliminary injunction. There are basically four, and I've got a four-part test up here. The first is, does the plaintiff have a likelihood of success on the merits? So if what you're doing is causing me harm and I need you to stop causing the harm, at least until we can get into court and have the court determine the merits of the situation, whether you can continue or not permanently, I have to be able to show that I at least have a legitimate claim. I have a likelihood of winning before a court will issue an order stopping you. Second, would the plaintiff suffer irreparable harm? In other words, is the kind of harm that you're causing, could we go back and undo it? Would money damages be sufficient, for instance? Or could we go back and undo the harm? Or would it be, at that point, kind of a runaway harm that we could never recover from? That's the second part of the test. Third, does the balance of harms favor the plaintiff? In other words, would there be more harm done by issuing the injunction than not? So when we balance the two parties' interests here, yours and mine, what does the court determine? Would it cause more harm than good or not? And then last, will granting the injunction cause some sort of public harm? And we have to look at the larger picture. What are we doing in terms of public policies? Is this a good idea to issue an injunction under these circumstances and the like? And then, of course, a permanent injunction is just like it sounds. It's a permanent version of the temporary order. And the court will have to make a determination on the merits before they issue a permanent injunction. Okay, our next remedy is the remedy of reformation. And this is an equitable remedy using the court's fairness powers. Think about reformation or reforming a written contract. This is where we see this. Remedy that allows the court to rewrite a contract to conform to the party's true intentions. I don't know if any of you have ever done any editing, but I put the red pen here on the slide just to kind of remind you of what the remedy of reformation is like. It's almost as if the court takes out its judicial red pen and will fix errors in a written contract. And when I say errors, that's kind of a broad term because sometimes the parties, when they go to write down their oral agreement, they put their oral agreement into writing, they misinterpret it, they mischaracterize it, they have a mistake in the writing, and the writing itself doesn't really conform to the party's true intention. And then by the time they get into court, they're arguing about, well, what was this true intention? And one party's saying, well, the writing says one thing, the other party says, yes, but that really wasn't what we meant, and you know it. And so when we get into court, the court can, using its equitable powers, basically agree to rewrite the contract, the written contract, to conform to what it determines is the party's true intention. So I always use this example. Let's say that you have a house for sale, and it's located, its address is 123 Main Street in Macomb, Illinois. And I come to look at it, and you're showing me the house, and we're negotiating price, and we agree on all the terms orally. It so happens you also own the house next door, which is 125 Main Street. But I never looked at that house, and I don't want to buy it, and it's much less valuable, it's smaller and in all respects. And so you go to write down our contract, but instead of writing down 123 Main Street, you write down the property at 125 Main Street. And without noticing it, I sign the contract. We get to the closing, and I notice the error, the mistake, and the deed that you give me has a different legal description, and I notice that it's got the address for 125 Main Street. And I say, oh, this isn't the property I was going to buy. We were looking at the one at 123 Main Street. And you say, well, that's what the contract says. The contract that you signed says 125 Main Street, so you have to buy that one. If I complain and we end up in court, I would ask the court for the remedy of reformation. I would ask the court to take its sort of judicial red pen, strike through the contract part where it says 125 Main Street and write in 123 Main Street, and then enforce that. That's what this power of reformation is. And also notice here that sometimes courts will use this reformation remedy to make the terms of a contract more reasonable than the ones that are written into the contract. And you can see this sometimes with covenants not to compete that we talked about in an earlier chapter, where the terms of the covenant not to compete may be sort of unfair or too broad. And so sometimes the court will use its reformation powers to go through and instead of maybe the non-compete agreement lasting for 5 years, the court might say, well, that's too long, and they'll take their red pen, strike through 5, and then say 2 years, and then enforce 2 years on the parties. Of course, courts get criticized for doing this if they do it too often, because then the court is substituting its judgment and its terms for the terms that the parties negotiated. And that's not the role of a court. Okay, now we're back to this idea of mitigation of damages, something that I mentioned earlier when we were talking about compensatory damages. This mitigation of damages doctrine says that the injured or non-breaching party actually has a legal duty. So once the other person in the contract breaches a contract with you, you have to understand that this doctrine of mitigation attaches a legal duty to you, even though you didn't do anything wrong. What it says is that you have to attempt to lessen your damages if possible. One really good area that we see this in are landlord-tenant disputes. So we'll use that for our example here of mitigation. Let's say that there's a lease for an apartment, and the lease is a 12-month lease. And the tenant pays and stays in the apartment for 7 months, and then after 7 months decides to leave and abandons the apartment, stops paying rent. The landlord contacts the tenant, and the tenant says, yeah, I'm moving out and I'm going to stop paying rent. And the landlord says, well, this is a breach of the lease. You still have 5 months to go and 5 more months of rent to pay. And the tenant says, yeah, well, I'm not going to do that. The doctrine of mitigation of damages basically says that the landlord now, knowing that the contract is going to be breached, has a duty to attempt to mitigate his or her damages, which means they have to attempt to find performance from another source. And in our context here with the landlord, they would have to attempt, it wouldn't have to be successful, but they would have to attempt to find a replacement tenant to come in for those 5 months to pay rent. Because the risk here is that if the landlord just sits back and does nothing and lets the 5 months roll on and accrues 5 months of unpaid rent and then goes in to sue the tenant and says, well, the tenant moved out, didn't pay 5 months worth of rent, and so I'm suing for all of that rent, the judge might say, well, what did you, to the landlord, the judge might say, well, what did you do to mitigate your damages? If the answer is nothing, then the landlord runs the risk of the judge saying, well, I think you could have found a replacement tenant, or at least it's someone else, and so I'm not going to give you all of your damages because I think you could have lessened them if you had tried and you didn't make any effort. Okay, the key here is that the non-breaching party has to make reasonable efforts. So again, it's whatever a reasonable person would do in the shoes of the non-breaching party in order to mitigate damages. So in my context, usually that means the landlord has to attempt to find a replacement tenant for those 5 months. What would that look like? Well, a reasonable attempt might be, an advertisement in the local paper. Maybe showing that apartment to prospective tenants along with other apartments. Maybe even getting a realtor involved, with finding a replacement tenant. Those kinds of efforts would be reasonable efforts at mitigation. Then, when the landlord sues for the unpaid rent, the landlord can come in and say, see, these are the efforts I've made in mitigation. Even if they're not successful, a court might be satisfied, well, at least they made a reasonable attempt. And then the court will give all of the damages. One note here, down there at the bottom of the slide, we have mitigation and sales under the UCC. Okay, so this has to do with buyers. Remember the rule for buyers and compensatory and consequential damages. Well, this is related to that. It says if the seller breaches a contract and the buyer attempts to remember cover is another word for mitigate damages, find replacement goods somewhere else from another seller, then a court will not award consequential damages. Okay, so if the seller breaches by not providing the goods under the contract, and the buyer doesn't attempt to make a reasonable effort to find replacement goods from another source, then when the buyer goes into court to sue the seller, a court won't award consequential damages, lost profits. All right, so you have to make those reasonable efforts. And so that's a little bit of a wrinkle there with our UCC rule. Okay, let's talk about contract language and remedies a little bit. Can we control what damages will be and what we'll be responsible for? Well, to some extent we can if we have a situation with liquidated damages. Okay, and I've covered this with penalties, and I'll talk about what those both are here. Liquidated damages are damages, the amount of which is determined between the parties before a breach. So a lot of times there will be language in a contract between two parties, and the contract language will say, in the event of a breach, one party agrees to pay the other one X number of dollars as liquidated damages. Liquidated just means determined, figured out ahead of time. So if one side agrees ahead of time, before there's ever a breach, in fact at the time they're signing the contract, that if I ever breach this contract, I will pay you X number of dollars as liquidated damages, then a court is likely to enforce that, at least where damages would be difficult to anticipate, right? An example of that might be, a construction project. Let's say we're a city, and the local city government wants to build a bridge over the local creek. And so they put the project out for bids for building contractors, and they hire one. And the contract they sign for building the bridge says that the construction has to be completed by June 1st. Time is the essence, the whole thing. And they go a step further. And in the contract itself that the builder signs, it says if the construction is not finished by June 1st, then the builder agrees to pay the city $500 per day as liquidated damages until the project is completed. And then they sign it. Then when we get to June 1st, if the project isn't completed by June 1st, then the builder has already agreed ahead of time what damages that they'll pay in the event that they're late on their performance. One thing about this too is that you use these where damages would be difficult to anticipate or put a dollar figure on. For instance, how much is it worth to a city not to have the use of a bridge for a day? Well, that's a hard thing to put a dollar figure on. But if the parties agree ahead of time it's worth $500 a day and that's a reasonable amount, then it's worth $500 a day. And a court would enforce that. Okay, liquidated damages are enforceable. Penalties, however, are not. A penalty is a provision in the contract that's designed to punish one party for a breach of the contract rather than to compensate the non-breaching party. Basically, the idea is courts aren't into punishing a party just for breaching a contract. So if the parties themselves try to slip in some language in their contract and one side really wants the other one to pay if they breach, not as compensation, but just to sort of, in the sense of a moral obligation, and so they stick some penalties in the contract, then a court is not likely to enforce that. What's a penalty? Well, I always use this example in my face-to-face classes, and that is a lot of you will sign leases for apartments. And I actually used to write some of these leases for our local landlords, and so I've seen all kinds of different provisions in these leases. But some of them I wondered about whether they were liquidated damages or whether they were penalties, but thank goodness never had to go to court to determine that. But one example I will use from a lease where maybe your lease is like this, where it'll have a provision that says the tenant agrees not to have any pets in the apartment or in the unit. And it'll go a step further. It'll say, and tenant agrees that if tenant is found having a pet in the unit, then tenant agrees to pay landlord the amount of $150 per occurrence upon being found with a pet, or whatever, some language like that. And then the tenant signs it. So the idea is the tenant will pay $150 every time they are caught with the dog or cat or whatever in the apartment. Is that liquidated damages between the landlord and the tenant, or is that a penalty? Well, the difference is in the purpose and the intention and the reasonable nature of the term. Courts would look at that, and when they're doing their analysis of it, they would say, what purpose does that provision serve? If it has a compensatory purpose, if it's designed to reasonably compensate the landlord for any harm that a pet might do, then it's okay. It's liquidated damages. It has a compensatory purpose. If its only purpose is punitive, if it's just to punish someone for having a pet, and it has no compensatory purpose, then it's a penalty, and it's not enforceable. All right, and it'll depend on the reasonableness of the terms also. If the lease had a $150 liquidated damages provision, per occurrence, that's more reasonable, because you can anticipate it, a dog, for instance, maybe a big dog, doing at least $150 worth of damage to an apartment. But if it used some exorbitant amount in the lease, and it said tenant agrees to pay the amount of $10,000 per occurrence of being found with a pet, a court is more likely to look at that and say, nah, looks like there's not a compensatory purpose here. No animal is going to do that much damage reasonably. This looks like just an attempt at a penalty. It's just to punish someone for having a pet. And we have the test down there for liquidated damages. This is what the court looks at. They'll ask two questions. First, at the time of the contract formation, would the damages be difficult to determine ahead of time? Like my bridge example. Is it difficult to determine, or would it be difficult to determine how much the loss of the use of a bridge would be for a day? Yeah, that's the kind of damages that you would want to use liquidated damages clause to determine. And then second, was the amount of liquidated damages a reasonable estimate of the harm to be caused, or does it look like it has a punitive purpose? Okay, and then last here, we do need to talk about punitive damages. Now, I just got done talking about penalties and how courts aren't looking to punish people just for breaching a contract. And then our next category of damages is punitive damages. You might be wondering what's going on. Well, punitive damages, just generally speaking, are damages awarded by a court to punish one side. Now, having said that, I have to kind of back up for a second, because in a breach of contract case, which is the context we're talking about, punitive damages are rare. In fact, the court won't award punitive damages just for a bare breach of contract at all. There must also be, on the part of the breaching party, some evidence of bad faith or fraud, something that the court wants to punish, in addition to just breaching a contract, right? Because the court's role in determining remedies and looking out for the non-breaching party is really to try to make the non-breaching party whole. It's not just simply to punish people for breaching a civil contract, okay? But when a person breaches a contract and they do it in bad faith, or they commit fraud while breaching a contract, then a court might step in, and because of that extra behavior, because that's also a tort, which is considered a civil wrong, then a court will step in and maybe award punitive damages so that that party won't do it again. And so this is where we see punitive damages. If it's just a straight breach of contract, if I just straight don't perform like I promised to perform, then if you sue me, you're likely not to get punitive damages unless, along with my breach, I also operate in bad faith or fraud or misrepresentation, something like that that the court wants to curtail. So just as a bare breach of contract, no, they're not available. So the next question that comes along with punitive damages, along with when a court will award them in a contracts case, which is rarely, second is how much. How much will a court award in punitive damages? Well, I have some factors there that the courts will consider for this. First, the R word, reprehensibility. The court will look at the reprehensibility of the defendant's conduct. What does that mean? Well, that means the wrongfulness of it. How bad was it? In terms of, an ethical, moral outrage, how reprehensible was what they did. If they operated in bad faith, how bad was it, for lack of a better way to put it? If they're operating, fraudulently, is this the only victim of the fraud? How much was involved in the fraud? Those kinds of things. How bad was it? That's the kind of factor that the court's looking at there. The second is the ratio between the harm actually suffered and the damages awarded. So the court will look at the actual amount of harm and say, well, this person operated in bad faith or they committed fraud, which we don't like, but they really didn't cause all that much actual harm. So in that case, there may be punitive damages, but they may not be large. And then last, the difference between the punitive damages and the civil and criminal penalties in other cases. Okay, so sometimes, especially with fraud, we have some criminal activity accompanying the breach of contract. So, a person might be arrested and may face some big fines or other punishments in a criminal case, and a court will take that into consideration when assessing punitive damages. They'll also take a look at the ratio between punitive and compensatory damages, and usually if the ratio is not completely disproportionate, then a court will be okay with awarding punitive damages.